today. Just wanted to let you know before I introduce the speakers that they have said that questions are welcome at any time, so you don't have to wait until the end. For those of you that are attending via webinar, please use the chat feature if you have a question during the presentation. So our speakers today, first I'll introduce Tim Gebhardt. He has served as the Vice President of Claims at Minnesota Lawyers Mutual Insurance Company since 1985. He is an adjunct professor at the University of Minnesota Law School, where he teaches a course on legal malpractice. He has served on the Lawyers Board of Professional Responsibility, the State Board of Legal Certification, and now serves on the Minnesota Board of Judicial Standards. He also serves on the Board of Professional Liability Defense Federation and is a past Vice President of Insurance for the International Association of Defense Counsel. Molly Iden, thank you, is also with the same company. She is a claims attorney with Minnesota Lawyers Mutual. Prior to joining Minnesota Lawyers Mutual, she practiced in the areas of insurance defense and general civil litigation. She's an active member of the Minnesota Defense Lawyers Association and is the MSBA, she is serving as the co-chair of the MSBA Life and Law Committee. And she also serves as a coach of the McGee National Civil Rights Moot Court team for Mitchell-Hamlin School of Law. Please help me welcome them.
Thanks, Liz. Thanks for having us today. We're going to spend the next hour discussing with you some issues of social media. And I'll say right out of the chutes here that as we go through this, there are a couple of things to keep in mind. One of them is to remember that because of what Molly and I do on a day-to-day basis, we look at all this stuff from a really paranoid point of view. So we're looking at it from the worst case basis because that's usually how we see these things develop. Secondly, a lot of the information that we're going to go through today might appear to apply to lawyers that are in private practice. I know some of you are law clerks. Eventually you'll be out in private practice. All of you have the opportunity at some time to do that. I think a lot of the ethical rules, a lot of the issues that we're going to talk about that we think might get you in trouble one way or the other, either ethics-wise or malpractice-wise, can apply to you whether you're in private practice or work in the public sector. We've got this quote up here from Gertrude Stein, and I think this kind of applies to the topic that we're talking about today. We're in a world of, I think, information overload. It's looked at in different ways by different people. You probably can't tell, but Molly and I are in a different generation. So we kind of look at these things a little bit differently. Hopefully today you'll be able to get a little bit of a taste of how Molly thinks about some of these things and how Molly's generation does and how my generation, the baby boomer generation, does. We're going to talk today about as many of these things as we can squeeze in an hour, about social media policies, how social media can affect attorney competence, the impact of social media on advertising, on attorney advertising, very importantly, the creation of inadvertent attorney-client relationships through social media, how it affects the way lawyers are communicating with clients and the way clients are communicating with their lawyers, and the impact it has on litigation. Evidence in social media, how it's affecting juries, and what's going on with judges. So before we really get going here, I'll ask those of you that are here in the room now, can you raise your hand if you are on Facebook? How about LinkedIn? How many of you use Twitter? How many of you use other things that Molly knows about that I don't? Okay, so almost everybody has some kind of a presence on social media. So the things we're going to talk about really apply to all of us.
So starting with just kind of the very first rule out there, Model Rule 1.1, competence. A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. However, key to our discussion here is comment 8. To maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, engage in continuing study and education, and comply with all continuing legal education requirements to which the lawyer is subject. Interestingly, the ABA Commission issued a statement saying a lawyer would have difficulty providing competent legal services in today's environment without knowing how to use email or create electronic documents. Staying current with benefits and risks associated with relevant technology pertains to how lawyers conduct investigations, engage in legal research, advise their clients, and conduct discovery. So does pretty much everyone here use email on a daily basis? Is there anyone who maybe doesn't? It's pretty uniform, I think, in how we practice law today, whether you're in private practice or not in private practice. Everyone is using email. How many people use internet, Google, to research cases or matters that you might be looking at? A lot of people. So you can see that, it is important to have sort of an understanding of technology, not only because it helps you do your job better, but also because the rules really are starting to imply you really have an ethical obligation to understand how to use technology.
And one other point I'd make in terms of the use of things like Google and the use of social media to do research on cases and on clients that come in. Think about it in terms of attorney malpractice and how the standard of care might be evolving. If, for instance, you're handling a case, you're handling a matter, and there's information that's available publicly on some social media site, and you fail to look there, and you fail to get that information, have you violated the standard of care? The rule that we put up is the ABA model rule, and the stuff that is highlighted in blue here is something that's just recently been added to the comment. But a lot of the states that we deal with are starting to look at modifying their competence rule and pulling this in, understanding how important it is for lawyers to understand the concept and the implications of social media.
So what is social media? I think, we did just a quick poll of who, was using social media, and it sounds like a lot of people are on Facebook. But for those of you who maybe aren't on Facebook, essentially, users, posting pictures, videos, news links, status updates, kind of breaking it down into the various examples. I like chocolate chip cookies. Twitter, users post 140 character tweets. That's where you have a lot of the hashtags. LinkedIn, users update job history, skills, education. So social media can be all-encompassing, as you know, from posting photos to posting things about your interests, your business, your job, where you're working. One thing that's somewhat interesting is Baker McKenzie. Most people know that. It's a pretty large global law firm. They have 59,832 followers posting updates of firm successes, leadership news, noteworthy legal development. So I think what we're starting to see is it's not just individuals who have Facebook profiles anymore. A lot of businesses do, a lot of companies do, because certainly there's a lot of useful marketing tools that can come from using these various platforms. But what we're talking about here today, there's always risks, ethical risks associated with doing that as well.
Okay, so for individuals, Facebook has over 1 billion users worldwide. Twitter processed over 400 million tweets in 2012. LinkedIn has 364 million members worldwide, and 65% of adults in America have at least one social networking profile. And it's going down, as Molly mentioned, to law firms too. 77% of attorneys use social media professionally. 75% use LinkedIn, 26% use Facebook, 19% use Twitter. And the example Molly gave about Baker McKenzie is kind of interesting with some of the things she said they're doing on social media. Because what do you think firms and lawyers are using social media for mostly? It's mostly to advertise. And there's a bunch of advertising rules that are in the Minnesota Rules of Professional Conduct. And we're going to go through some of those as we get into this.
So this is a cartoon that we had found in, I think it was the ABA Young Lawyers Division magazine, for anyone who might get it. But we think it's just sort of an interesting representation of a vintage smartphone. And it really just kind of shows, where we came from to where we are today, and, oftentimes the learning curve that's associated with having to keep abreast of all of the new technology changes.
And I think we went through most of this slide, but most firms do have an online presence. Now, most of you here work for the courts, right, that are in the room? The court's got an online presence, doesn't it? Both the Court of Appeals does, the Supreme Court does. So a lot of this will apply to you. Do you know if somebody is in charge of monitoring everything that's up on the court's websites, for instance? Here is a one person or one department in charge of that. Can anybody go up and stick stuff up on there? Do you know who posts on the court's websites? Have any of you ever visited the court's websites? You don't have to raise your hands. With law firms, this is a real important issue about who has access to do things on the websites, what they can do and how they're able to do it. For the law firms and for the lawyers who have these sites, it's the lawyer's responsibility to monitor their sites and to remove social media content by others on the lawyer's social media webpage. You've got to monitor it for comments, for endorsements, for recommendations, to ensure that third-party posts aren't violating ethical rules.
So this is kind of just following up on that a little bit further, and probably more relevant to, thinking about private practice, especially for law clerks who might be, moving on. Making sure that your firms have a social media policy for the reasons, just described.
Well, let me ask you a couple of questions again now personally. Most of you now are working for, in public service here, not at this point probably in private practice. How many of you have got a blog of your own? Does anybody here, I guess you don't have to raise your hand. Most of you, if not all of you, have got some social networking sites. There's video sharing you can do on YouTube and on Instagram and Snapchat. There are comments on news sites and podcasts. You have to be careful with all of these things. You have to really be careful with all of these things.
And we'll go into examples sort of on, people who were posting things on Twitter or on Facebook, but have any of you, not that you've posted it, but that you've seen other people, or heard in the news, stories or situations where, you're not posting it on your firm's website, you are posting it on your own Facebook page, comments about an ongoing case, an ongoing trial, something that you're working on. Has anybody seen that before? Otherwise, we have plenty of examples too.
Now, one of the other things that I think kind of falls into the social media category, and some people argue with me about this, but do all of you know what listservs are? Listservs are a networking community. Is that a good way to phrase it?
Yeah, I think it works that way.
That you can join. They're usually practice specific, I suppose. So if you go to the Minnesota State Bar, for instance, to their website, you can get on a solo and small firm listserv. And what that is a deal where if you join it, you can post questions and you can post comments, and it goes out to everybody who's a member of that listserv. And generally speaking, they're going to be people that of a kind of a like kind that you are. So if you're on the solo small firm listserv, which is something that's really popular because solos and two-person firms usually don't have somebody in the office next door they can go talk to about an issue. So they'll use the listserv. They'll post questions on the listserv. Have any of you ever dealt with this issue? Then they lay out the issue. And then they'll wait and they'll get responses. Those scare me from my paranoid point of view, because I think if you answer one of those posts on the website, what are you doing? Very possibly. You're probably giving legal advice, aren't you? And you may very well have created an inadvertent attorney-client relationship. We'll get into that a little bit later. But those are the kind of things that you have to keep in mind. Some of this stuff that might seem sort of innocent, that might seem sort of helpful, I think can get you in trouble pretty quickly if you don't think it through.
So turning now to focus on marketing, and we can go through these slides relatively quickly because we do understand, as government employees, you're not really doing a lot of marketing probably at this point in your career. But marketing, a lot of people, again, are using social media for that, helping to build relationships and referral networks, joining groups of interest, following thought leaders and experts in the field, learning new subject matter, raising awareness really about, you and your practice. I think the example of Baker and McKenzie and all of the people who are following, Baker and McKenzie, it gives them an opportunity to, say we won this, $5 million settlement, and it allows them to sort of highlight the successes that they've had. 23% of lawyers using social media said yes when asked whether their use of social media resulted in getting new clients.
We mentioned some ethical rules relating to attorney advertising. They start with 7.1 and go through 7.5. We're not going to go through all of these now with you in detail, but if you do get to a point where you've got a firm or you've got your practice set up and you're going to get out into the world on social media, you've got to be very, very careful about staying in compliance with the ethical rules that relate to advertising. If you have questions about whether or not what you're doing is going to violate any of the rules, I think the best thing to do is to call up the Office of Lawyers Professional Responsibility and get an advisory opinion from them. Let them know what you're going to do. Those advisory opinions are very, very helpful. If they give you an opinion and somebody later raises an issue about something you're doing based on the opinion you got from them, chances are you're not going to get sanctioned by the OLPR. You get the responses pretty quickly. The one caveat is you got to ask them for their opinion before you do what you're thinking about doing. Don't do it first and then ask them, because you'll get in trouble.
I have a question online here. The question is Florida an outlier in this respect, or is it just ahead of the curve?
An outlier in which respect?
I don't know. I'm just reading the question.
Well,
sorry.
Oh, okay.
The Ethics Advisory Committee of the Florida Supreme Court has opined. I'm not aware. That it is ethical misconduct for a judge to friend on social media site a lawyer who may appear before the judge. Is Florida an outlier in this respect, or is it just ahead of the curve?
I think I probably should know this because I'm on the Board of Judicial Standards, but I can't tell you exactly right now. I think they're ahead of their times. We're going to talk some about a judge getting in trouble a little bit later on here with some social media stuff.
And you can, whoever's listening online, that is actually a slide that I have, and I have that exact same Florida court example. So that's way to read the PowerPoint and be on board with my notes there. So that is, I think, certainly something to be cautious of. Certainly if you're practicing in Florida, but if you're practicing here as well, you just need to be careful about, friending judges, that you might be appearing in front of, and, how is that going to look, both from the judge perspective, how if, you're the prosecutor, you're friends with the judge, how's the defense, going to look at that as well. So I think absolutely that's something to be cautious about, and certainly, Florida has a court case, directly addressing that as well.
There are a couple of things on this slide that have to do with the issue of the attorney advertising rules. In general, a social media profile that's used personally isn't going to be subject to the attorney advertising rules. However, a social media profile posting or a blog that a lawyer uses primarily to generate business or to retain business is going to be subject to those rules, starting with 7.1. You have to be careful of hybrid accounts. You should keep your personal and your professional sites separate. And importantly, don't lose sight of a lawyer's duty under Rule 1.6 to maintain confidentiality when you're utilizing social network sites for marketing. So what you don't want to do if you settle a great big case for your client that's subject, for instance, to a confidentiality agreement with the other side, to post on your Facebook that you just got $1.6 million for your client. You have to be careful.
So how many people said that they were using LinkedIn in this room? Anybody? So almost everybody uses LinkedIn. It's certainly a very good kind of business networking, easy to create and maintain contacts that way. But LinkedIn also has sort of a landmine of potential ethical issues, especially because LinkedIn invites lawyers to identify specialties or what they are an expert in. Minnesota Rule 7.4, lawyer may communicate the fact that the lawyer does or does not practice in particular fields of law. Okay. However, lawyer shall not state he or she is a specialist except when the lawyer has been certified by an organization approved by the Minnesota Board of Legal Certification as a certifying organization. So clearly you can see the problem that can arise when you are on LinkedIn and you are saying that you are a specialist or an expert if you don't actually have, the civil trial specialist designation. I think a lot of times people tend to just overlook that when LinkedIn is saying, get your profile to 100% completion. So you start filling in these things and maybe overlook, well, I'm not technically designated as a specialist. Two courts, or I guess one court and then two ethics opinions have specifically addressed this very issue. South Carolina in 2012, attorney disciplined for using sites such as LinkedIn and lawyers.com to misrepresent his specialization. Again, Florida and New York ethics opinions prohibit lawyers and law firms from listing specialties on a social media website unless lawyer or firm actually holds the specialization. So I think that is sort of, where we're going to see probably a lot of state interpretations of that rule with specialization and listing specialties going, just looking at, Rule 7.3.
And if you look further at 7.3, it kind of lays out the fact that solicitation. Under this, unless the solicitation is to a lawyer, a family member, or a close personal friend, a lawyer shall not solicit professional employment in person or through live telephone or real-time electronic contact. Think about whether or not an electronic medium is real-time electronic contact. I don't think it's too much of a stretch for somebody to argue that it would fall under Rule 1 or 7.3. Be really careful with instant messaging in chat rooms, which can be potentially more immediate, more intrusive, and more persuasive. And let me ask you another question now, those of you in the room. How many of you use instant messaging? How many of you would think that instant messaging might be an okay way to communicate with clients? You think you could do that? And if you do use instant messaging to communicate with your clients, are those communications, or should those communications be a part of your client file? And if they should be, how do you keep them? Where do you keep them? Who's got access to them? If you're talking about over instant messaging, for instance, attorney-client privilege information, anybody else see that? Is that secure? These are some of the things that make me very nervous when I talk about or think about the things that lawyers are doing now that are getting to be kind of mainstream.
Well, and I think just to kind of echo off of that is, I think chat rooms, maybe a lot of, my generation doesn't really use chat rooms that much, but I think a lot of people might use GChat, where you are, directly communicating with your clients. And I think that's where you run the real risk that you could have clients who maybe are in your contact list. They send you, the quick instant message that's not a chat room, but they're asking questions about their case, not through email, through the little chat box on the screen. You're, providing updates back and forth to them. I mean, I think without a doubt, you need to make sure that you find a way to print off, that entire kind of chat screen or chat history and put that in your client file. So I think that's another way to think of it, not necessarily in terms of just chat rooms, on the internet, but in your own email. There are a lot of people that use Gmail for, conducting their business email and might be G-chatting with clients. And I think it's just important to make sure that any communications with clients, go into the file.
Now, do you know if that's secure?
I think so. I have no idea actually, but it's in your own email. So I think there's the distinction that way between maybe a general chat room on the web. If anyone in the audience has any idea if that's secure, let us know.
And I can tell you that if a claim is made against a lawyer, a malpractice claim is made against a lawyer, and they're sitting in the office with their defense lawyer, and the defense lawyer asks them the question I just asked Molly, and the answer is, yeah, well, I think so, but I really don't know. It's going to make the defense lawyer really, really nervous. So keep those things in mind. We mentioned a little bit about the inadvertent attorney-client relationships and creating those. Those scare me a lot. When you think about the fact that whether there's an attorney-client relationship, which is really one of the cornerstones of pursuing a legal malpractice claim, whether or not that relationship existed is going to be a question of fact for the jury. It's not a question of law. It's going to be a question of fact. In my experience, and I think Molly would probably agree with this, from her experience in dealing with malpractice claims, is that whether or not an attorney-client relationship existed is going to be in the eye of the client or the potential client. Now, how many of you, because you're lawyers, have had a friend or a neighbor or somebody you bumped into figure out that you were a lawyer and start asking you questions? And they didn't care what your job was, what you did at work every day, or where you worked. They just figured that you're a lawyer, so you should probably be able to answer their questions about patent law, or about family law, or real estate law. Because in the minds of a lot of the public, if you're a lawyer is a lawyer is a lawyer, and you should know all of this stuff. Those kind of interactions, I think, can happen through social media. And if you look enough, I mean, most of you here said you've got a presence on Facebook. Most of you got a presence on LinkedIn. I know on Facebook, you could invite, or you've got a profile, and you probably say on there that you're a lawyer, right? No? Some do, some don't. Those of you that do, if you say you're a lawyer, anybody that's able to see that can ask you a question, can't they? And if you give them an answer, you're probably going to be their lawyer. Because if they ask you a question about a legal issue and you answer them, they're going to, in their mind, you're going to be giving them legal advice. And you wouldn't give legal advice to a non-client, would you? That's how these relationships can occur. And it gets pretty dicey sometimes, because we deal with lawyers oftentimes who will argue with us that this person can't make a claim against me because I didn't represent them. And the client will swear up and down, we thought that he was our lawyer. Or she gave us the advice, we asked her a question, she told us what we could do. And that's going to be in the hands of the jury then to decide. So watch out about having open invitations online, and I think this applies mostly to websites. And there's some, people will argue with me about whether or not a website is social media. I sort of think it can be, because there's a lot of interaction that can go on between people through websites. There are law firms' websites and lawyers' websites that actually invite questions. There are lawyers' websites that will post sample forms about, you want to sell your house, you want to get a divorce, you want to do these different things, just click here and we'll give you some help. And they've got a little disclaimer, or maybe a big disclaimer somewhere saying, nothing on this website or nothing we're doing on this website is providing legal advice, and we're absolutely not your lawyers. But my guess is if somebody takes up their advice, it doesn't work out the way that they wanted it to, and they sue the lawyer, they're going to argue that I didn't see any of that. I didn't pay any attention to any of that. And a good example of that, I think, is how many of you have gone into like the Apple store or gone into an app store on your phone and you sign up to download an app, and the first thing you get is a big agreement, right? And before you can download that app, you got to click that you agree to all of those terms, right? Have any of you ever read through one of those to see what you're agreeing to? You have? You're the first one that's ever admitted to that.
You gotta learn contracts somehow.
But that's can be a little bit scary because you don't know what you're agreeing to unless you read that.
So these are just kind of the key takeaways of the inadvertent attorney-client relationship. A lawyer may provide general answers to legal questions asked on social media. However, a lawyer cannot provide specific legal advice because a lawyer's responsive communication may be found to have created an attorney-client relationship. A lawyer may not solicit business from the public through real-time or interactive computer access communications, including instant messaging and communications transmitted through a chat room. So just things to kind of keep in mind. So this, we kind of touched on this a little bit already, retention of social media communications with clients. If a lawyer uses social media to communicate with a client relating to legal representation, the lawyer should retain records of those communications just as if the communications were memorialized on paper. And we often use this as sort of a segue to attorneys who may or may not text message with their clients. Does anybody here text message with clients if you're representing state agencies or anything of that nature? A lot of people don't, because they think it's too risky. First of all, why would I want to have, my clients texting me at all hours of the night? But a lot of people are now starting to text because, clients, that's how a lot of people communicate. Do you think that's part of the client file? Should you have a copy of those text messages then if you're exchanging them back and forth? Right, absolutely. That's really no different, I think, in today's day and age than an email or a letter that you've received. It's a different type of communication, but clearly still a communication. And we've had issues where a client or a claimant will have a copy of a text message, that they're using as part of their legal malpractice claim saying, well, this is the text message that they sent me. We'll talk to our insured and maybe they sent it, they don't really remember, but that's the type of stuff that, you need to be careful, as always, with what you're saying. It's certainly very easy to send off a quick text message that may have a very different connotation or meaning than what you mean it to, and just making sure that you have, a copy of that put into your file.
And one of the big problems that comes about in that, if you take the example that Molly gave, where a client shows up with something that arguably the lawyer sent to them by text messaging or instant messaging, you don't have it in your file, there's going to be an adverse inference that you're trying to hide some other stuff. What else do you have that you didn't turn over? And what happens in the course of discovery is that the court will sometimes order the one who doesn't have what they think maybe they should have to hire a forensic computer person to come in and go through all of their hard drives on their computers, go through their phones and investigate the whole thing. And those are expensive. Another issue that's really important with this whole social media talk we're doing is the issue of confidentiality. And Rule 1.6 is a rule about confidentiality. And it's very important that you keep this in mind because it's so easy, I think, to say some stuff to somebody you shouldn't when you're using social media because it's so fast. It's way fast. I think that it can apply whether you're in private practice or you're working in the public sector. Think about the times that you've been sitting at your desk working on something, on court business, for instance, and it's getting to be 5:30, 6 o'clock, and you were supposed to meet someone for dinner, or you had an appointment somewhere, and you get a text message from your friend, says, where are you, when are you going to be here? And you're in the midst of reviewing a bunch of stuff for work that's privileged, but it's a really interesting issue. And you end up just kind of on the spur of the moment saying, I'm not going to be able to come for another hour or two. I'm working on this case. It's really interesting. It involves this, 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 and this. And I don't know what the judge is going to do with it, but I think probably this is going to happen. And off it goes. Is that a problem? It's a big problem. You really have to work hard at maintaining confidentiality. I really don't know. I'm assuming, I think I know that your cell phone provider has access to everything that you're texting from your phone. Should you be sending attorney-client privilege information or any kind of privilege information by text then over a cell phone? Somebody else can get hold of it. The fact of the matter is I don't know who all can get hold of it. I know that it's tough to get records from Verizon or from AT&T to get copies of things. Eventually they'll destroy them. But keep those things in mind. And a lot of this stuff Molly and I are talking to you about today, we don't have a whole lot of answers for because this whole thing is just really developing. But it's developing quickly. So if we today in the 15 or 20 minutes we've got left with you, can accomplish our goal to scare you into thinking about some of these things, we really will have accomplished our purpose here today.
So taking an example sort of, online breach of confidentiality, a lot of people are thinking, well, of course, who would ever do this? Well, unfortunately, there's tons and tons of examples of these various types of cases out there. So one such example, former Illinois assistant public defender was fired and received 60-day suspension for commentary posted on blog that amounted to violation of Rule 1.6. This individual frequently referred to clients by first names, nicknames, or jail ID numbers, described the client's cases, drug use, and other embarrassing and potentially harmful information, even critiquing courtroom testimony. So these things, they do happen. It seems almost like common sense. Why would you do that? But so many people out there, they just they don't use some of their common sense, which I think a lot of this is when you're, posting your clients' names, facts about their specific cases.
For the case of the Miami-Dade, Florida public defender that was representing a defendant on murder charges. The defendant's family brought fresh clothing to wear at trial. Corrections held up items for routine inspection, and the public defender snapped photos of leopard print underwear and posted the photo on her personal Facebook page with a caption suggesting the client's family believed underwear was appropriate for trial. Prior to the incident, the public defender allegedly posted on Facebook a statement that called client's innocence into question. The Facebook page was set to private, but somebody saw the post and notified the judge who granted a mistrial. The public defender's office fired her, stating that when a lawyer broadcasts disparaging, humiliating words and pictures, it undermines the basic client relationship and it gives the appearance that he is not receiving a fair trial.
So turning the focus a little bit on other ways that people are using social media, one such way is service of process through email. As you can imagine, it's relatively uncommon. Granting of a request of service of process through email, it really depends on the facts of each case. One such example, Snyder versus Energy Incorporated, plaintiffs showed the court they had made reasonable efforts to locate a current physical address to serve defendants, and they had the president of the company's email address and had sent an email requesting a physical address to serve process that went unanswered. In that case, the court did hold service by email was reasonably calculated under the circumstances to apprise the corporation and the president of the action and was an appropriate form of service.
See, some of these things can trip the lawyer on the other side up. If this service is made, the client goes to the lawyer and says, I got an email. If the lawyer isn't paying attention to what's going on, the lawyer might not understand that now it could be that service by email is proper. Might advise the client not to do anything until they're properly served, and the client goes into default because they didn't answer on time.
Another example, service of process through Facebook. Some of you might have heard about this right here in Hennepin County District Court. In that case, the judge stated that service upon a defendant who presumably lived in the Ivory Coast could be possibly made via email, Facebook, MySpace, or any other social networking site. The court stated the traditional way to get service by publication is antiquated and prohibitively expensive, and that technology provides a cheaper and hopefully more effective way of finding the defendant. So certainly still very, I think uncommon throughout all of the jurisdictions, but, perhaps it does show a changing way of the legal system in affecting service of process.
And we talked a little bit earlier about using some social media in your practice and whether or not the use of social media in the practice is starting to change the standard of care. And there are a couple of cases now, and I mentioned before that Molly and I, being there's a little bit of an age difference, think differently about how we would go about investigating a case that comes into us. What happens in our office now with most of the claims attorneys is the minute they get assigned a case, the first thing they do is go hop on the computer, get onto Google, get onto Facebook. They look up the insured lawyer. They look up the plaintiff's lawyer. They look up the defendant and see what they can find. And they actually kind of get to know everybody, all of the cast of characters in these things almost immediately when they first find the case. And you guys find some interesting stuff.
We do. Oftentimes we'll have, for instance, a personal injury claim where an attorney may have missed a statute of limitations, and so now the case within the case of the legal malpractice case is still where a claimant is saying they were severely injured in a car accident, they can't walk, or something of that nature. Well, if you pull up their Facebook page, they're out water skiing, they're out doing all these things. These happen all the time. That's a kind of an extreme example, but it helps you not only sort of do some investigating into what their claimed injuries are, it helps kind of just give it an overall understanding of both, who your insured is, what the plaintiff is going to be like on the stand, just to provide a sense of overall kind of what you're going to be dealing with in this case.
In terms of standard of care, it works both ways, because now I think what's pretty much standard for plaintiff lawyers when they make their first, have their first meeting with a client when they've been retained to represent them, is they will find out from the client what exactly they're doing on social media, and a lot of them are telling their clients to get rid of their social media because they understand what the defense is doing. A couple of the other things, a couple of cases, one from Indiana, Munster versus Groce. Court was incredulous that plaintiff's attorney, who was trying to serve absent defendant, had failed to Google him as a matter of due diligence. The court itself did so and immediately obtained search records that yielded a different address for the defendant, as well as an obituary for defendant's mother, who listed numerous surviving relatives who might have known his whereabouts. There's another case, this Du Bois case, effectiveness of an attorney who only checked directory assistance in an effort to get the addresses to serve missing defendants, questioned the court, compared such a method in an age of internet and social media as the equivalent of using the horse and buggy in the 8-track stereo.
So this is what Tim was talking about just a few minutes ago, ethically gathering information. Just certain, rules to always keep in mind, Rule 4.1, 4.2, and 8.4.
So do you think you can go on to Facebook and try to friend somebody who's adverse, then use the information you get when you get into their site? It's a good question. You can't do that. Informally searching social media networks for potentially incriminating client or content. A lawyer can look at the public portion of a person's social media profile, even if such person is represented by another lawyer. However, the lawyer's got to be aware that certain social media networks may send an automatic message to the person whose account is being viewed, which identifies the person viewing the account as well as other information about such person. Now, apparently LinkedIn does that. Is that right?
That's right, yeah.
So you have to be careful. You have to know the things that you're using and what they do. Private settings create an illusory sense of false security. Formal discovery requests relating to social media platforms. Courts largely find that individuals have no reasonable expectation of privacy with social media networking platforms.
And I think one thing that's interesting is that one court has noted there can be little privacy on a social networking website. For instance, Facebook's purpose is to help you connect and share with people in your life. This can only be accomplished by sharing with others. It's only the uninitiated or foolish who could believe that Facebook is an online lockbox of secrets. So I think that statement by a court just kind of summarizes this whole concept in one statement.
I find it pretty amazing what people will put up on their Facebook pages, to tell you the truth, and not have them be private, that you can go in and see some pretty amazing, disgusting stuff. The federal courts take a little bit different approach.
So these are some of the approaches: the threshold, time frame related broad approach, limited disclosure approach, in-camera review approach. The general principle emerging seems to be that information on a private social media site, which is only accessible to those people who the user permits, is discoverable subject to limits a court may impose. So again, even though you have it on a private site, it's still sort of the false sense of security oftentimes.
And this gets to the example that I stated earlier about the attorney that's representing a client. The attorney is aware a former employer is represented by counsel. The attorney sends out a friend request to two high-ranking company employees whom the client has identified as being disqualified or dissatisfied with the employer and likely to make disparaging remarks about the employer on a social media page. A friend request gives only attorney's name. The attorney intends to use any relevant information he obtains from that social media site to advance the interests of his client in litigation. Did that violate a rule of professional conduct?
Well, this is an actual San Diego County Bar Association legal ethics opinion. Court there looked at Model Rule 4.2, looking at 4.1. I think probably in particular here, the attorney's duty not to deceive. And in that case, the opinion held that lawyer's request violated both the rule against contacting a represented party and lawyer's duty not to deceive others. Suggested lawyers seeking access to a represented party on social media must seek information through formal discovery or contact the party's attorney to request consent to such a communication.
Here's another case to look at that's interesting. Two former employees allege sexual harassment by a former employer. The defendant sought information about the former employees that was available on social media networking sites. In this case, the court held that the defendant was entitled to some of the documents, including status updates, wall comments, causes or groups joined, activity streams, and blog entries. The court noted that content on social networking sites is not shielded from discovery simply because the content is locked from public view or is private. You want to do one more of these? We're kind of running out of time.
Yeah, I would say we'll probably go ahead and just start talking more about, if you want to flip ahead a few, it's talking about trial publicity. So this is actually a Minnesota case. So prosecutor in Minnesota posted on her Facebook page that she was, quote, keeping the streets of Minneapolis safe from the Somalis. Obvious issue with stereotyping and spelling here. But the post appeared during the beginning of jury deliberations in a criminal case with a defendant that the prosecutor perceived to be of Somali descent. Defense counsel used this post as part of the basis for a motion for a new trial and later as one of the grounds for appeal.
And this is another case that probably most of you have heard about, the Trayvon Martin case. Defense counsel used Twitter and a website to raise money for his defense and to make public statements. The parents started an online petition demanding Zimmerman's arrest. Attorneys scoured potential jurors' profiles using Facebook postings to keep two people off of the jury. During the prosecutor's questioning of a witness, it became apparent that he didn't understand how to use Twitter when he was unable to lay the proper foundation to admit a Twitter page into evidence. One of the defense lawyers posted a photo on Instagram of his daughter that became the subject of a prosecution motion for inquiry.
And I think what's interesting in that photograph, what it was a photograph showing this attorney eating an ice cream cone with his daughter that had the caption of, quote, we beat stupidity cones and, quote, dad killed it. And this post took place the day after a tense cross-examination with one of the prosecutor's witnesses. The defense attorney said, this photo had nothing to do with the testimony. I had taken it the day before any of this happened. But certainly that's not an issue that you want the judge to be focusing in on is, was there any sort of misconduct on the defense attorney's part in that case?
I'm going to mention one more case here, and then we're going to be about pretty close to done. And this was a case that was actually one of our cases that we were set to try last July. It was down in Iowa, and what happened was the Iowa trial court postponed the trial after a Facebook post by plaintiff's counsel asserted that the defendant had slept with his client and beat her up. In the post, the plaintiff's counsel argued the fact that the Supreme Court reduced the defendant's license suspension to 18 months instead of 4 years as recommended by the grievance commission, and that was another example of why an all-male court needs a woman. So this was posted, I think on a Thursday or a Friday. Trial was to begin on the following Monday. The case was kicked in and set back a couple of months. Think about that in terms of the defendant and the insurance company in the case. The added expense that went into this because of these posts made by the plaintiff's attorney. The defendant had geared up for trial, was ready to try the case. The case gets set back 2 months or 3 months. At that point in time, they got to kind of start all over again. The expenses go way up. So these things can cause a lot of extra expense, and it shows just a real lack of judgment. Now, this was a case that was to be tried in Des Moines. The argument was this kind of a post was going to really do bad things to the jury pool. And the lawyer on the other side said, well, it's not really a big deal. This was only able to be seen by my friends on Facebook. Well, it was a big deal because it turns out she had over 8,000 friends. And then the other thing that happened when this started to get a little bit of publicity is the Des Moines Register did an editorial about this issue and printed the whole post in the paper. So you can imagine if you were trying to get a fair, impartial jury in a smaller community like that, what that would do to the jury pool.
And I think if we just flip forward a few slides, just the type of publicity that you don't, one more I think. The type of publicity that you don't want social media to cause. So this is an article that was published November 30th of last year. Judge's Facebook pimp post leads to reprimands, new trial.
And again, this is another example of, well, the reprimand is bad enough for the judge, but it led to a new trial. So the case was tried, was over and done with. This comes up, has to be tried again. It increases the workload of the courts, the lawyers, and everybody. We've run over our time by a couple of minutes. We would like to thank you for having us today. If Molly and I will be around here, if any of you got questions afterwards. I don't know if there were any other questions from the online, but thank you very much for your attention.